So I have an update for you in the Made in Texas Suppressor lawsuit, which aimed to remove the NFA and ATF's control of certain suppressors made in Texas. So let's talk about what is happening. Now, really quick before we jump into this video, I actually want to kind of do a call to action. A lot of you guys are aware of what's going on right now on the East Coast with the hurricane and the devastation that it caused in a bunch of communities in Tennessee, North Carolina, and others. Right now, they need a ton of help. And some of my friends, some fellow YouTubers like Jared from Guns and Gadgets and Mike from Mr. Guns and Gear, they've been trying to get additional aid to people who need it. So I'm going to leave some links down below. One of them is to Jared's PayPal. All the money that you donate is going to be used by him to buy supplies, and those go almost that same day to those areas. And then also Mike from Mr. Guns and Gear, go watch his videos. He's doing a ton of updates on what's going on in the communities over there, but he's working with the U.S. Veteran Corps. And so I will leave a link to them down below also where you can donate, and all of those funds are going directly to those communities. As I mentioned in the intro, in this video, we need to talk about what is currently going on with the state of Texas and their Suppressor Freedom lawsuit. This law, as many of you are aware, was passed by the state of Texas, and there was a subsequent lawsuit which essentially aimed to eliminate the NFA and ATF's regulation of Made in Texas suppressors. The case we're going to be talking about and discussing is the Paxton versus Dettelbach case. This case was ultimately thrown out by a lower court because the judge there believed that the plaintiffs in this lawsuit did not have standing to bring this lawsuit. The state of Texas then appealed that up to the Fifth Circuit. They wanted a reversal of that decision, and ultimately what ended up happening, we've talked about on the last video covering this, that the Fifth Circuit ruled and sided with the ATF, finding that the plaintiffs did lack standing. Since that decision, we've been waiting to see how the state of Texas and the plaintiffs would respond, and now we have an answer, and it appears like they're going to refile the lawsuit and try to cure some of those standing issues, so they're not going to seek en banc panel review. Now, for those not aware, this lawsuit arises out of Texas House Bill 957, which passed just a couple years ago. HB 957 aimed to exempt from federal regulation all suppressors that were made in and remain within the state of Texas. The claim behind this law was that since these items were made and sold exclusively within the state of Texas, they did not fall under interstate commerce, and they could not actually be regulated by agencies like the ATF. They fell outside of federal regulation. Now, as a result of all of this, Texas, along with individual plaintiffs, then filed a lawsuit against the federal government. The case was then submitted to a federal district court on cross motions for summary judgment. And then after review from the district court judge actually ruled in favor of the federal government. They ruled in favor of the ATF. The court ruled that essentially that the plaintiffs here lack standing to bring this lawsuit. Some of the basic requirements are, first, that there must be a concrete injury in fact. That is not just simply hypothetical, so you have to show an injury in fact. Second, there must be causation or something that is traceable between what the federal government did and the injury that was caused to the plaintiffs. And then finally, there must be some sort of what's called redressability, essentially some form of relief that can be granted by the court to cure whatever injury that you suffered. On review, the judge here found that the plaintiffs did not suffer an injury in fact, and therefore he ruled that there was no standing. Here, the judge essentially stated that the individual plaintiffs would have to allege that they possess an illegal silencer, but also the judge here found that the plaintiffs here could cure the standing issue by simply going through the NFA's process, going through the registration process, and whether or not they were approved or denied could actually cure this issue. And one of the last things that this court did here was the judge found that the state of Texas actually also did not have standing, that they could not stand in the place of the individual residents in Texas and sue on their behalf. So also they found that Texas was not an appropriate plaintiff. And based on all of that, the judge granted the federal government's motion for summary judgment and dismissed the case in favor of the ATF. Now, of course, in response, the state of Texas and the plaintiffs then appealed up to the Fifth Circuit, and they wanted the Fifth Circuit to reverse that decision. The ATF responded to that appeal, and they argued that the Fifth Circuit should affirm what the lower court said down below. They should affirm that dismissal. The ATF argued that under the Tax Anti-Injunction Act, also known as the AIA, that this lawsuit was improper since it would result in the avoidance of paying a required tax under the NFA. So they tried to use some tax implications to also have this case thrown out. And then the ATF also claimed that the plaintiffs here still did not have standing, that they didn't go through the process to register these items, and that they haven't suffered an injury in fact, and therefore also, again, they did not have standing. And the cherry on top with all the ATF's arguments, of course, is that they claim that this application here, that the NFA process in general did not violate the Second Amendment. In fact, in the ATF's briefs, they stated that because the Second Amendment covers only bearable arms, laws that regulate firearms accessories or attachments do not necessarily implicate its protections, and a silencer is a firearms accessory. It's not a weapon in itself. They went on to also state that even if silencers were bearable arms, their inclusion within the NFA means that they are dangerous and unusual weapons or dangerous and unusual items, and therefore they fall outside the scope of the Second Amendment's protection. That, of course, runs directly contrary to what the ATF actually does. The NFA actually regulates these items as true firearms, but the ATF wants to forget that. They want to say that these are simply accessories, even though the federal law treats them as actual firearms. But on review, the Fifth Circuit ultimately agreed with the ATF. There was a decision from 3 judges, Edith H. Jones, Edith Brown Clement, and then Corey Wilson. And they kind of took the easy way out, and they found that, of course, that the plaintiffs lacked standing to bring this lawsuit, and therefore they affirmed what the lower court said, dismissing the case for a lack of standing. Mainly, that decision from the Fifth Circuit focused on the fact that the plaintiffs here, in their declarations, did not show that they went through or even attempted to file the forms under the NFA, that they did not take any action in regards to their suppressors, and based on that, the Fifth Circuit here found that they did not have standing. In the decision, the Fifth Circuit stated that, for 2 reasons, we find that these declarations are insufficient to establish a serious intention to engage in conduct prescribed by law. First, the declarations do not state any intention to engage in conduct prescribed by law. Rather, the declarations state only that the individual plaintiffs intend to personally manufacture a firearm suppressor for their own non-commercial personal use. But as the federal government points out, the statutes at issue do not prohibit the individual plaintiffs from making a firearm suppressor. Rather, they only prohibit making a firearm suppressor without complying with the applicable procedures and requirements, i.e., applying for approval, paying the requisite tax, registering the suppressor, and labeling it with a serial number. They go on to state that here the opposite is true. The individual plaintiffs have only stated an intent to personally manufacture a firearm suppressor, but say nothing about whether they intend to personally manufacture a firearm suppressor without applying for government approval, and they make no claim that they are statutorily ineligible for such approval. They go on to say that second, the declarations lack the necessary detail to establish that the individual plaintiff's professed intent to make a silencer is sufficiently serious to render their fear injury imminent rather than merely speculative or hypothetical. So really one of the frustrating things about what the Fifth Circuit did is they're kind of playing this semantics game based on what the declarations state. The plaintiffs said that they want to actually make these homemade suppressors, made in Texas suppressors, but the Fifth Circuit found that in their declarations, they did not state expressly that they intend to make these on their own, but not actually go through the approval process. So simply because they didn't say like, hey, we're going to do this and we're not going to comply with federal law, that was enough to say that they did not have standing, that they would have to say, not only do we intend to make these made in Texas suppressors, but oh, by the way, we also are not wanting to go through the process, or we do not intend to go through the process, or that we haven't gone through the process. So again, kind of semantics, but that's what the Fifth Circuit found, and they upheld what the lower court said. Now, since then, what we've been waiting for was a mandate to be issued by the Fifth Circuit to the lower court, essentially mandating what they said in their decision, affirming what the decision said, kind of codifying it, and then leaving it up to the district court. Now, the mandate has issued. That was issued on August 13th. And once that mandate is issued, well, then the clock starts to run as far as when the plaintiffs in the state of Texas can file for en banc panel review. But as of right now, the clock has finally ended. The time has run, and the state of Texas and the plaintiffs have not filed for a new appeal. They have not filed for en banc panel review, so that option is now up. And what that now means is that the state of Texas and the plaintiffs here have ultimately decided to not go for additional appeal up to the Fifth Circuit, which I anticipated that they would not, because if you already have a 3-judge panel ruling against you based on standing, it's very unlikely that the en banc panel in the Fifth Circuit will side with you. You've already lost some of those judges. So I anticipated that they would try to relitigate this, and it appears that's what they're going to do. They're probably going to file for the process here, maybe find some new plaintiffs that have gone through the process, or have these individual plaintiffs now go through the process, or change some of the declarations, file a new lawsuit, change some of the declarations, and expressly say that not only do we intend to make these made in Texas suppressors, but we intend to do this without going through the process. So with that Fifth Circuit decision, the ATF has won temporarily, but I anticipate that the state of Texas here, if they want to keep their HB 957 law, this Made in Texas suppressor law, still valid. They're going to refile, relitigate this. So for everybody asking about what's going on with the Made in Texas suppressor freedom lawsuit, that's what's happened. That's what we're going to be looking for now going forward. So if anything else changes, if anything else develops, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. Also, don't forget, links are down below if you want to donate to those people out in Tennessee, North Carolina, and others who have been hurt by the hurricanes. Again, links are down below and also in the pinned comment. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.